Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about searching the offices of professionals. Cases that should have gone to the Supreme Court of Canada, but didn't. Under legislation that governs professionals like doctors, accountants, real estate agents, and lawyers, governments or the regulatory body, as the case may be, are entitled to apply to the court for an order to allow them to search the offices, homes, and places that belong to individuals who are regulated by those professions. This is a case that arose in Ontario, where one COVID-denying doctor was the subject of a regulatory investigation by the College of Physicians and Surgeons. In the course of that investigation, the college demanded a list of all patients that the doctor had prescribed alternative medications to try and treat or prevent COVID. The doctor refused to provide it, and the college applied successfully for an order that they be permitted to enter and search the office of that doctor to obtain those records. The doctor challenged the constitutionality of the provision, arguing that it wasn't legitimate to allow the regulatory body this extensive power to search just to further its investigation. And this case raises really important issues, because at the end of the day, a lot of regulatory bodies in Canada are being taken over by government. And to give government the same power that an independent of government regulatory body may have to conduct searches of places where there is a high expectation of privacy, like with your doctor, like with your psychologist, like with your lawyer, is a significant issue. And the standards for allowing these searches are quite low. So assessing the constitutional ambits of this permission and assessing whether or not this is something that is actually justifiable in a free and democratic society, even within the limited expectations that you have as a regulated professional, is an important issue. This is especially so because legislation that allows regulatory bodies or governments, as the case may be, to conduct these searches allows them to enter into very private spaces, usually on the basis of a less stringent standard than would be applied for by the police if they were looking for a search warrant. And having a government or a regulatory body have access to that much personal specific information that strikes at your biographical core is a significant intrusion into privacy. There are likely better ways that this same goal can be accomplished, and it would be nice to see legislatures explore the way in which these same goals could be accomplished, and the Supreme Court of Canada to give guidance to help legislatures understand how to best protect the privacy rights of people who are regulated and protect the public in the capacity of those regulated professions doing their role in regulating them. Unfortunately, it's going to take another case for the Supreme Court of Canada to consider truly the extent to which the power can be used to search the private places of people who are subject to regulation. Hopefully they hear one soon so that we know how this is going to play out when more governments take over more self-regulating professions. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.